Welcome to a live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
Well, if all goes according to plan, today should be the final hearing for Donna Sue Adelson inside a Leon County courthouse before her trial commences 1 week from Tuesday on August 19th. Welcome, everybody. This is Surviving the Survivor, the show that brings you the very best guests in all of true crime on trending criminal cases. And for those who are new to this case, it's been trending far too long. Since 2014, that was the year that Dan Markel was shot and killed in his driveway back on July 18th of 2014, succumbing to his injuries the next day on July 19th. And through some really amazing investigative police work and through the help of a next-door neighbor named Jim Geiger, a senior citizen who happened to spot a vehicle, Tallahassee PD were eventually able to trace down two men, Sigfredo Garcia, Luis Rivera. One, Luis Rivera, is a member of the Latin Kings gang. The other, Sigfredo Garcia, a childhood friend of Luis Rivera. And Sigfredo Garcia had children with a woman named Katie Magbanawa. And that woman, Katie Magbanawa, at one point dated Charlie Adelson, the ex-brother-in-law of Dan Markel. And sure enough, they were able to link these people together. Charlie Adelson, convicted in a murder-for-hire plot back in 2023, is now spending the rest of his life in Florida. However, because of the defense that they used, throwing the Latin Kings gang members down during the defense, because of that, Charlie Adelson was moved to a state pen in South Dakota, where, as far as we know, he is currently living. The other family member, of course, the hitmen convicted, one of them, Luis Rivera, cut a deal. He'll eventually get out. He's the only one. And the middle woman, Katie Magbanawa, turning down a plea deal. She'll be spending the rest of her life in prison unless something unusual happens. And 1 week from Tuesday, jury selection begins for Donna Adelson, the matriarch of the family, the person that the government says is the mastermind of all this. Some say, well, no, it was Wendy Adelson, the ex-wife of Dan Markel, and the question remains, will she be indicted next? Time will eventually tell. But right now, it's about Donna Adelson, and here to help us break down this hearing that is set to start in 9 minutes. And Judge Stephen Everett, presiding in Leon County, which is Tallahassee, is usually right on time. But here to help us break down, the Professor Emerita, the Professor Joe Patuto, 2 words, I guess, not just 1 word. It's the Professor, but that's all you need to know. Joe Patuto, you've been following this case with us incredibly closely. It's going to be you and I, and thankfully you more than I, because you actually really understand the law. What do you think we're in store for today?
Well, at least there are several motions scheduled. Whether they've resolved them behind the scenes this morning or yesterday, we don't know. But the defense has at least three motions in limine. 2 of them, I think, will be resolved relatively quickly. They relate to whether a couple of the investigators, primarily Jason Newland and Corbett, can give interpretive or semi-opinion testimony. There's another one that's kind of a blanket one about any state witness giving opinion testimony. Those should be resolved relatively quickly, I would guess. There's also another another defense motion in limine that we don't know. We don't know what it is because it was entered under seal, and I think the state responded under seal. So hopefully we'll hear about that this morning.
And let me just stop you right there. So why some of these things, like the depositions, have now been sealed? You just talked about this motion in limine, that's sealed. Why are they sealed?
There has to be something in them that the defense believes will prejudice or affect the ability to impanel an impartial jury. We don't know on the one that was under seal, we don't know what's in it, but that's the reason for that one. The other two they're going to be pretty routine. Non-expert can't give opinion testimony. There's no indication that the state is going to do it. That the defense will be able to object at the time if something like that comes in. But those are going to be very, really quick. But the motions in limine in general are to keep out evidence that the defense or the state believes is inadmissible, and to keep it out, get the judge on alert beforehand, keep it out ahead of time so they don't have to object at the time. And to some extent, both the state and the defense need to know about it, because if something is going to be kept out of evidence, they won't be able to refer to it in opening statements. If the judge decides it can be entered in evidence, then they will be able to decide in opening statements. So the motion in limine allows them to craft their opening statements more carefully. So anyway, there are 3 motions in limine that we know about from other hearings or that are on the docket. The state also has one, and this one again I think will be resolved relatively quickly, and if it hasn't been already, and it relates to whether the defense will be able to refer to Luis Rivera as a member or a major leader of the Latin Kings. So those are those. Then there are 2 other motions that one of which I think may take quite a while. One is the defense has remade its motion that the information about Donna being arrested at the airport on her way with a one-way ticket to Vietnam should not be entered in evidence at all. The defense argues it only goes to character or propensity. It's not relevant to any issue in the case. If it is relevant, then the prejudice that would come from it outweighs any probative value. So they're remaking the motion that the judge has already ruled on. That one, I think the judge is going to deny again. And then the last one relates to the new investigation that started in October, and more particularly to the 2 informers, Dina Bernhardt and
Patricia Bird.
Patricia Bird. I was trying to think of her first name.
Mm.
Thanks. And whether their information should be admissible. Again, it goes to whether, in part, whether it's going to relate to any issue in the trial, and also whether it's too prejudicial. So those are the ones we know about. Whether there's anything else that has been discussed behind the scenes that may come up, I don't know. There's another looming motion out there, and that's the change of venue. But I don't think they'll be doing much about that today because it's still premature. They really can't handle that motion definitively until they've tried to seat a jury.
Which was the last one you just mentioned?
That's the change of venue.
Yeah, that's
what I don't think that's going to happen today. That they've got to wait on that one until they're trying to seat a jury the week after next.
Yeah,
but that's the other one that's open that I know of.
Yeah, and that's the one I was going to ask you about, because obviously if there's going to be a change of venue, that seems, I guess, Joe, that would only come into play if, for whatever reason, they can't seat an impartial jury in Tallahassee. But I got to tell you, having been up there multiple times and talking to people, and I've had a lot of people email me saying, hey, I'm interested in this trial. I want to fly in from Milwaukee. Hey, I'm interested in this trial. I want to fly in from Toronto. But I got to tell you, when you're in Tallahassee, it's different. It's not like the whole town is talking about this.
Most people are not. Most people are not, heavily invested in, true crime stories or trials.
So it's the
exact opposite with their lives, and they don't know about it. I agree with you. I don't see it succeeding, but they won't be able to do it until they try. And I suspect what will happen is the defense will make the motion, and they will continue to raise it or try to produce in voir dire evidence to support the idea that it's not going to be possible to seat an impartial jury.
Yeah. And obviously Donna is supposed to be there today in person. She's been moved since I think the last couple of hearings to Wakulla County, which is the neighboring county. So she was probably driven in very early this morning. They typically wake up the inmates at like 2 in the morning, so she might be a little bit groggy, but I'm sure she's anxious for this particular hearing. Look at this. This is wild. Tell us if you're from exotic locale. We've got St. Andrews, Scotland, home to the British Open. This is where they started playing golf 600 years ago with those funny bunkers. So shout out to St. Andrews, Scotland. And just equally as exotic, you've got the Commonwealth of Pennsylvania and Peggy Schaefer. So we've got people from all over. In Pennsylvania, they've got golf courses that are probably in the winter so hard and rough that it feels like cement is another way to say it. But this motion regarding this kind of consciousness of guilt related to Vietnam, it's already been rejected.
Right.
In order for that to be suppressed, give us an example of something that the defense would have to bring to the table for the judge to suddenly say, okay, that's not something that can be brought in.
Well, it would have to be some new evidence. You just can't remake a motion based on what you made a motion about before, because that's resolved.
Mhm.
It would have to be some new evidence. And I don't think there is any here, but I suppose something that might work is if the defense can produce witnesses to say, hey, you know what? There was a round trip ticket. This is a mistake that there was only a one-way ticket. That would be new evidence that might relate to, it certainly would relate to the question as to whether it was consciousness of guilt. Or if there's more evidence that they're going to unturn, is unturn a word? You know what I mean?
Yeah.
It's too early in the morning for me. That Donna and Harvey made trips to Vietnam on one-way tickets several times in the past. Or that they had talked to people about, we just want to get away, but we're going to be back, in a week or 2 weeks. You can see that evidence all would be relevant to that question. But the one thing we know is none of that evidence exists. So I cannot imagine any evidence that would really impact dramatically on the decision that Judge Everett already made that is out there. If it was out there, they would have raised it long ago.
Look at this beautiful Buffalo, and Buffalo is beautiful. Actually, you couldn't pay me to live there. No offense, because they get 5 feet of snow every other day. Scotland back in the house, and Buffalo we love. I go visit this time of year, but definitely not in the winter. And then you've got Jersey in the house, which is where the professor is coming to us live from, and that is my home state. So obviously, we are partial to the great state of New Jersey, even if there are oil refineries lining the turnpike, and sometimes it smells horrendous. Round trip or one way from Bree, who's always in the chat, and get to see her this morning. Interesting. Round trip or one way wouldn't make a difference to me. I think that's probably the case, but the fact that these people had the means and went out and bought a one-way ticket, and remember, Harvey was apparently on the phone with Scott Radius, a friend of the family who was helping them in Vietnam, trying to get his money back after. It'd be the absolute last thing on earth. Singapore with Armand Fence, but getting my money back while my wife is in jail for murder would be on the lower end of things that I would be concerned about if I'm Harvey Adelson and I own a lot of real estate and I've got a lot of money, even if I am spending a ton of money on defense attorneys. But this is, again, just to set sort of the stage for this morning. There is a pool camera as per usual. It is now 2 minutes after the hour. Usually Judge Everett starts right away. So we are not in control of the camera. But when it starts, and we've got a live picture, I can see it. We are going to bring it to you, the COE, and shout out to Space Coast up early on the West Coast. And shout out, that's a good time for me to just thank everyone. We have the best show. We've got the best people behind the scenes and the best community. And I will die on a hill arguing that. But here we've got the COE behind the scenes, chief of everything for those who are new, also known as my wife. She runs the show. We've got Space Coast on the West Coast. He puts out all the audio podcasts. We are found anywhere you listen to podcasts. We do this nightly show every evening for those who do not know or not familiar. There is the seal of the great state of Tallahassee. I got to get a better look. I believe this might be the larger courtroom. I'll have to take a look.
Yes.
Yeah, this is the
Yes.
larger courtroom. This is where the trial will be. People were asking. I will be heading up there with Meave Moen, our other great team member, otherwise known as Steve Cohen. And Steve and I will be driving up there a week from Monday for jury selection on Tuesday. And of course, Joe Patuto will be here throughout the trial. She is offered from New Jersey to give us her legal expertise. And every day we'll probably rotate some guests in with her during the trial for like color commentary purposes. Think about Monday Night Football. You've got the play-by-play. That'll be the judge and the lawyers, and then the color commentary will be Joe Patuto and others who will be rotating around. Many of the people who you've seen on the show already. But this is a highly anticipated trial, and we will be taking it live each and every day. Jury selection likely will not be on camera, but I will be in the courtroom, and I'll be reporting and then doing a show every evening. And then somehow we're going to try to squeeze in other news of the day periodically while we're up there. The trial is expected. Charlie Adelson's trial, the son, lasted 8 days with a verdict that came down in under 3 hours. Prognosticators say that this should last a little bit longer. You've got 2 trial attorneys here, whereas with Charlie, you really had one in Dan Rashbaum. Here you've got 2. I mean, Joe, do you agree with that assessment? Do you think it's going to be...
There's different evidence for Donna. You've got both the Vietnam trip and the information, if the judge decides it's admissible, coming from the 2 jailhouse informers. So that's those are 2 chunks of new evidence that were not heard in Charlie's trial. 2 lawyers and lawyers who are more active making motions and making arguments. So their style is different from Daniel Rashbaum's. And so that alone will extend it some.
Yeah. And
I think the defense will actually be putting on witnesses this time. And in Charlie's trial, I think besides Charlie, there might have been 1 witness that they called, if I'm remembering correctly. So all of that is going to add to a longer trial. Yes.
Yeah, and Joe, here's a question for you from Premiere 2000. If Wendy gets on the stand and blurts out, "Hey, I did this." There's Donna, by the way. Let's take a look. She's in an orange jumpsuit. Typically, she was wearing purple, but she's now in what color? It's interesting because just last night, we did a show with former inmates talking about Donna's life if convicted in state prison. And someone said they're no longer allowed to wear orange jumpsuits because of the show, Orange is the New Black. Well, apparently that's not the case. But look, Donna talking with Jackie Fulford, the funeral director and attorney, and
They seem to have a close relationship.
Yeah.
The jail records as to who's visiting, it's Jackie exclusively on those records in terms of phone calls and things. So Donna's contact with the defense team seems predominantly to be going through Jackie and not Josh. The question about what happens if Wendy blurts on the stand, which of course is not going to happen, is it will be admissible. If indeed it's a blurt out, in other words, Georgia doesn't ask the question, "Did you do it?" Or there isn't anything that in the question that Georgia asked that should have elicited that sort of comment. Immunity it covers your responses that are reasonably within the scope of what the prosecutor's questions are. But if you want to blurt out something that's well beyond the scope, that's not covered by the immunity. You are not entitled to say, "Hey, I got immunity. Let me see how many things I can now say that they'll never be able to use." So it's got to be within the reasonable scope of the question. If Georgia again says to her, "Did you commit this crime?" and she says, "Yes," that would be covered by the immunity. But if Georgia says, "What did you do on the day your ex-husband was murdered?" and she says, "I did it," that's likely not within the scope.
Today, what do you think? By the way, we've got look at this, Siem Reap or Reap, I don't know how to pronounce it, Cambodia, and this person has been here before. Welcome to Edge of the Lake. and we've got Johannesburg, lest you think we are not an international show. When we're on early, we've got the global audience here tuning in, and a lot of people don't want to miss that. But of these motions that you described today, Professor, which is, I guess, the meatiest, which will take and consume the most time before Judge Stephen Everett today?
Well, if they do the one we don't know what it's about, that might be the lengthiest. But of the ones we know about, I would assume it's going to be the motion on evidence coming from the new investigation, primarily because this one will be one that Judge Everett has not heard before. So this will be all new. And I think the defense cares a lot about trying to keep that evidence out. State will care a fair amount about keeping it in. So that would be my assumption, that that's the one that will take the longest, in part because a couple of the other motions should take no time at all.
Yeah, Tucson, Arizona, where I met the COE, reporting at KGUN 9 News there, which is a historic TV station. There's Josh Zellman. He just sat down. We haven't seen Judge Stephen Everett, which is interesting because he's always the first one out with a big smile. And I'm excited to see Judge Stephen Everett. We've bumped into him at the Metro Deli, which is Tallahassee is not a small place, but it is a small place. And most people by the courthouse go to eat at the Metro Deli. The Metro Deli, more than once, has promised me that they were going to restock their Metro Deli T-shirt so I could have it as a memento. And this time around, I'm going to beg them. I'm going to probably call in advance and say, look, the trial's starting. You better get the T-shirts. Mexico City Pictor is there, unless that is supposed to be picture. I don't know, but they are there in the chat, and we appreciate that. And look at this, watching from Wakulla County. Come say hi, Penny Green. Anyone who's going to the trial, shoot me an email, survivingthesurvivor@gmail, and let me know. It's obviously, this stuff is really serious. Jimmy McNutty, a trial watcher since the OJ days, and I've got some OJ stuff in my studio, Jimmy. But I met Jimmy on our book tour, and I will see him in LA, and I'll see him out there. For those who are looking for some summer reading, the book that I've written about my mother, childhood Holocaust survivor, it is available on Audible and anywhere you buy books right now, Surviving the Survivor. And last night, speaking of that, was Carm's birthday. We took her to a dinner. I posted some pictures on Instagram at Surviving the Survivor, the Netherlands in the house. But Carm, 86 years old. And Joe Patuto, she had a heart attack because we sneaked it by her, told the waiters, and they came out banging drums. It was an Argentinian steakhouse. And so they were dressed in crazy stuff, and they were banging drums in a packed steakhouse. Here comes the judge.
There we go.
Stephen Everett presiding.
Hi, Judge. He's not smiling.
No, he's not. Maybe he didn't have breakfast yet. I don't know. We're going to listen in here. Joe will give us her pearls of wisdom as we go. This is the final hearing for Donna Sue Adelson ahead of her murder trial, beginning with jury selection August 19th. Judge Stephen Everett, no nonsense, universally loved by everyone at STS Nation, and I think even his wife and everyone else. He's got his game face on today.
Yeah, I just wonder what happened before he took the bench.
Yeah, he didn't get his coffee.
Or they had something that went on.
Yeah,
you know,
it is unusual.
It's
9:12. He's always out right on time. So
right.
That begs the question: did something happen? Again, Donna, noticeably in an orange jumpsuit, wearing glasses. Her hair appears to be a bit more coiffed this morning. Last time we saw it in a quasi ponytail-ish kind of thing happening. And,
no, it was in that. She got a haircut before the last hearing because we've seen.
Here this morning in State versus Donna Adelson, 2023 CF 3226.
That's a little
for the final pretrial hearing this morning. We're going to address all of the outstanding motions and also some matters pertaining to the trial, which is still scheduled for the selection of the jury starting on August 19th. The parties can make their appearances for the record.
Georgia Kappelman for the state.
Jackie Fulford for Mrs. Adelson.
Joshua Zellman for Mrs. Adelson.
I
Is there a
believe
change
we
in
have
there?
several defense motions to address. Ms. Kappelman, the state has not filed any additional motions in limine that have not already been addressed by the court.
That's correct, Your Honor.
Right. Let's start then with the motion in limine concerning the court file relating to the dissolution of marriage. Mr. Zellman?
Thank you, Your Honor. Your Honor, as is my custom, I lay it out in motion. It's our position that the vast majority of the court file, even with the court taking judicial notice, is inadmissible. It's irrelevant. Paragraph 7 of my motion provides a somewhat comprehensive list of the items that are in there that have no bearing, have no relevance, they're not material in any way to this case. And so we're asking that, aside from very limited number of items that the state can establish has relevance and is not barred by hearsay, we're asking the court exclude that file.
Ms. Kappelman, which parts of this file is the state seeking to admit as a part of its case in chief?
The entirety.
Right. As to the items that deal with, as identified in paragraph 7 of the motion, what exactly would be the relevance first? And what is your argument as to hearsay?
For relevance, Judge, it goes to the motive, the level of intensity of this litigation, the volume of the paperwork suggests that it was very litigious and went on for some time. The words that are used are strong, even hateful, and this was a cause that was adopted by the defendant, as the emails evidence will show. So it's important for the jury to understand the foundation of this motive is this litigation that began with the divorce, continued beyond the divorce with the child custody issues that developed later.
All right. So in part, the volume of what occurred over the divorce proceedings, you want the jury to recognize this goes to motive in some way.
Yes, Your Honor. In reference to hearsay, the items are not being offered for the truth of the matter asserted. There obviously was a litigious divorce, but it's being offered to show the effect on Ms. Adelson. These items were shared with her. The evidence intends to show she was very involved in the pleadings. She was sent the pleadings and offered detailed responses for how Mrs. Wendy Adelson should respond to the pleadings. So it's very bound up in the state's theory of the motive for the case.
All right. Mr. Zellman, as to your client's emails to her daughter as this litigation was going on, are these contested in any way?
With respect to the initial dissolution proceeding, no. However, in reviewing the emails, the post-dissolution matters that were filed by Mr. Markel, there's no evidence in those emails that those pleadings were shared with Mrs. Adelson. And so certainly, if the state's theory is that it goes to the motive, and that's the way of getting around hearsay, they have to establish that the pleadings were sent to her. My review of the emails show that did not happen. So they can't go to show my client's motive if she didn't receive that.
As to any pleadings that correspond with emails or communications that were made by the defendant and otherwise demonstrate her role in or some part in the divorce case, as to those, I'm going to rule they are admissible. The pleadings themselves, if they're being offered not for the truth of the matter asserted, but to otherwise demonstrate motive or intent, those are admissible. However, Ms. Kappelman, as to the bulk of the file itself, I do believe the defense is raising a clear point on this. Absent a connection or a nexus between the defendant and specific aspects of the divorce file, what is your argument concerning it?
I mean, there are pleadings in there that are not necessary to show the motive, but I did offer the exhibit itself in its entirety to demonstrate the bulk. If Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant, may I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstrative. You may also ask questions that generally deal with the amount of filings and also the volume of the case, but ultimately to responses for production or mediator notices, I'm inclined to agree with the defense as to that point. If there's not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case, all of it does not come in as substantive evidence. But I do want to make clear on this point, Mr. Zellman, as to what the witnesses will testify to, and none of us will know this until the evidence actually begins. This file can be used for purposes of impeachment, and it can also be used for purposes of rebuttal. Depending on what the witnesses say, what might be not a part of the state's case in chief may still be available to them through other means that are permitted by the rules of evidence. Is everyone clear on those?
Yes, sir.
Yes, Your Honor.
All right, let's move on to the motion in limine concerning the testimony of Sarah Youssef. Mr. Zellman.
Again, Your Honor, we stand on the motion.
Ms. Calvin.
I would just ask Your Honor to reserve on her. The state has no intention of calling her, so I don't think, unless that changes, that there's any reason to address her testimony at this time.
Well, and I assume you are going to leave Ms. Youssef available as a rebuttal witness if necessary.
Yes.
If the witness is not going to be called, it essentially moots the issue. On that point, Mr. Zellman, the state is not committing to calling this witness. If they do call them at that time, I will issue a ruling concerning your motion in limine.
Yes, sir.
As to any purpose of rebuttal, ultimately what comes out as a part of the defense case, Ms. Youssef still is able to testify in that capacity.
If we hear about the banana bread, Yusuf will be relevant to
Yeah, the
it.
next motion in limine concerning the testimony of Stephen Webster. Does the defense have any argument that has not already been made through the pleading?
No, Your Honor.
Ms. Kaplan, in response.
Judge, I agree with some of the defendant's motions. I don't think Mr. Webster can offer opinions. For example, his testimony, of course, will be governed by the same rules of evidence that every other witness is governed by, but he does offer some relevant points. So I think I should be permitted to, I don't know, these motions kind of blow my mind because it's like we want to pre-litigate every statement, including potentially objectionable statements that can be addressed during the trial by a proper timely objection. So I would ask that it be handled in that way.
Right, concerning the testimony of Mr. Webster, Mr. Webster, in his capacity of representing the deceased, certainly can testify factually as to what his involvement was with the divorce case. And also, he may testify concerning the nature of the proceedings as to any opinions that go beyond that. Ultimately, I think that's where we are going to have to get into what is being asked and what would be the response that ultimately the defense would find objectionable. But generally, as to any opinion that Mr. Webster cannot give without a proper foundation, I think it's settled as a matter of evidence that no witness gets to generally opine on matters in which they are not qualified to testify to. Is any other ruling being sought concerning Mr. Webster beyond that by the defense?
Well, yes, Your Honor. In prior trials and in deposition, Mr. Webster testified about statements made to him by Mr. Markel. Those are hearsay. There's not an exception. Those statements weren't shared with anyone else, certainly not my client. Those were statements that were made during the meeting in May of 2014 that Mr. Webster. There's no exception that I'm aware of under the hearsay rule.
Statements made by the deceased to Mr. Webster. Ms. Cattleman, do you have an argument?
I think I agree in general that those statements would be hearsay. I don't recall what my theory of admissibility was in prior trials, but I would agree to approach if I intend to elicit a statement made by Mr. Markel to his attorney and offer my theory of admissibility prior to asking the question. If I decide to do that in this trial, I don't think I plan to do that, so it's hard for me to address what that theory might be now.
Very well. Again, as a general principle of evidence, hearsay that has no exception is not admissible. If the state is seeking to admit this statement for a proper purpose that actually has a basis in the rules of evidence to be admitted, you will need to approach so that way the information is not placed improperly before the jury. The motion in limine is granted as to Mr. Webster offering any opinions for which he is not qualified to give. The court will reserve ruling on the issue of any statements that he may testify to by the deceased, if the state, again, will have to present an actual exception to hearsay in which the matter can be placed before the jury. All right, the renewed motion in limine concerning the Latin Kings. Mr. Zellman?
Yes, Your Honor. This goes in part to the theory of the defense and why Mrs. Adelson acted the way she did, the language that she used on the 2016 wire calls. Typically, I know that we would want to have the foundation through her testimony for that, but if the court were to bind our hands in questioning the state's witnesses, it would be too late to wait until she testifies. We would lose the ability to cross the state's witnesses on that issue. It's very limited. You have Luis Rivera. There would only be a few questions at most. Potentially Charlie Adelson, depending on when the state calls him. Certainly special agents. I believe it's Jimenez.
The last trial, he outright testified that he was, I guess, that he's pretending or trying to influence your client and the member of your Latin King was gay.
Yes, sir.
To that end, Ms. Cattleman, what is your argument?
Same as my argument has always been on this issue, Judge, which is that Rivera was a gang member. That's why he was recruited to do this. I think that's relevant. But the fact that he was a leader of a specific gang, I think is just bad character evidence that doesn't lend anything additional, more prejudicial than probative, and I would ask to exclude those details.
Similar to what we had in the last trial, as to this painting character of Mr. Rivera specifically in a negative light, the court's ruling will remain the same. As to the witnesses, though, Mr. Jimenez or other witnesses that may bring up this topic unsolicited on their directs, once the horse is out of the barn, it's out of the barn. As far as any cross-examination of Mr. Rivera specifically, the defense may cross-examine Mr. Rivera as to his role as a gang member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the killing of Dan Markel. Now, with regard to undercover or the former undercover agent, this is where I believe the analysis begins to diverge on this topic. He specifically approached the defendant as a Latin King member, correct?
No, sir. My recollection is, I know that was his testimony, but I would instruct him not to say Latin King in the future. However, he didn't say anything to Ms. Adelson about being a Latin King. I guess that was his version of acting like a gang member. I don't know how well he did. Ms. Adelson didn't seem to think he did very well, but that was the intention. He did not represent himself to her verbally as a Latin King gang member. He was not wearing any clothing or other signifiers that he was a member of a specific gang. I think the idea was just, you're an associate of this killer who is a gang member.
In response on that topic, Mr. Zeldin.
Just looking at his previous testimony. My role, I'll quote from page 1067 of the trial transcript of Mr. Charlie Adelson's case. Starting at line 20, question, can you explain what that operation was? Answer, my role in that operation, I was portraying a Latin King gang member and I was instructed to conduct with that. Continuing on 1068, question is, all right, when you say you were posing as a Latin King gang member, did you announce yourself as a Latin King gang member to the person you approached? I did not, okay. So you're just, that's the role. That was my role. You're a character. That is correct. That is his testimony. And yeah, I believe that once, especially with the call that my client made to the undercover on May 6th of 2014, when he became verbally aggressive towards my client, that factors into his role as a Latin King gang member. And I know in the previous hearing last year, Your Honor questioned whether there was a difference between Latin King gang member and simply a gang member. The answer is absolutely. In Miami, in South Florida, there is absolutely a difference between a gang member and a Latin King gang member.
Even with that being said, this ultimately goes to your client's state of mind, who is going to establish that he knows the difference between, forgive the pun, the garden variety gang member and a specific gang member.
I think between her testimony and anticipated testimony of Charlie Adelson.
Well, as to the questioning of the former undercover officer or special agent Jimenez, I will permit the defense to question the former special agent as to whether he was portraying a member of a specific gang as a part of his operation. Depending on what the answer is, we're going to revisit the issue of whether the name of Latin Kings needs to be specifically uttered as to either Mrs. Adelson or Charlie Adelson testifying concerning her state of mind and knowledge of the Latin Kings. As it goes to state of mind, the defense may certainly inquire as to that during the defense case in chief. As to Luis Rivera, the court's ruling will remain the same as to his leadership role or specific affiliation. The fact that he is a gang member may be inquired into, and the fact that he has had, or the fact that he had, or his role while he was recruited in this case, that certainly is ripe for cross-examination and may be inquired into. But as to him being a specific Latin King, that is where the line is going to be drawn. Do we need clarification on this ruling?
Just one here.
Not from the state judge.
So it sounds as though they're going to call Donna.
Interesting. Interesting. By the way, a lot of people are asking, but this is just subpar audio from the courtroom.
Part of her state of mind, her level of fear, is that it's not just that she left his Latin King, but that he was the leader of one of the branches of the Latin Kings in South Florida. That heightens her fear. And of course, she will testify to that.
I cannot make her testify. If she was committed to do so as part of her defense, that's her choice. But ultimately, someone with competent knowledge has to testify to this fact. Eliciting information about state of mind in the witness that either not spoken to your client or either has no knowledge of the state of mind, I'm not sure how that can be accomplished other than either your client herself, her son, or someone else who has direct knowledge of her state of mind at the time, unless you have an argument.
So I guess the way that we could accomplish that, Your Honor, is that Mr. Rivera, he is under a defense subpoena. We would ask that he remain for the defense case so that we can call him on our case in chief.
That's fine. Mr. Rivera, as I recall, never had direct communication with your client, but this is to elicit another relevant matter.
That's correct, Your Honor. It would be, once we establish the foundation, I would want to recall him for the specific purpose of him confirming that he was a leader of the Latin Kings.
Very well. Mr. Rivera will remain under the defense's subpoena until the conclusion of the trial. Let's move on to the defendant's motion of limine as to the interpretation of emails, recorded phone calls, and text messages. Which witnesses is the defense referring to concerning this motion?
Your Honor, I think it goes really to retired Detective Isom, Special Agent Sanford, potentially Jason Newland. I think a number of witnesses have offered interpretation of statements that were made. Now, we're not talking about coded language. Coded language is treated different. What we're talking about is the emails, the recorded phone calls, and text messages, other than coded language. What we're asking the court, because it has come out so frequently, that the court prohibit the state and, what's good for the goose is good for the gander, the defense, from asking someone other than an expert to offer an opinion about what someone means by an email, what they meant by a statement, or what they meant in a text message, aside from the language that's used itself.
Ms. Connelly, response?
I agree, that would not be admissible.
The motion in the limine is granted as previously raised in the argument on this matter. Any matters that would go to a code in which a witness could lay a proper foundation on this issue. Certainly, they may testify as to that point, but any general opining as to what an email, a phone call, or a text message means will not be permitted unless there is a proper foundation that can be laid by that witness. Next, the defendant's renewed motion in limine concerning travel as consciousness of guilt.
This is the renewed motion.
Yep.
This is the Vietnam one. Arrested at the airport.
Right. I know that the court previously ruled on this issue that allowed the state to use this information in the argument. The new information has been laid out in paragraphs 4, 5, 6, and 7. I stand on the motion. Those additional pieces of information had not previously provided the court, and I think that it's significant because it goes to her state of mind for making the travel plans and for going to the airport and for stepping on the jet.
The new information.
The counsel's argument correctly, Mr. Rashbaum did raise the fact that there was no legal process subpoena or warrant for your client, correct?
I believe that's correct.
Response, Ms. Calvin?
Judge, I don't think this is new information. This was never disputed. I don't think it changes the analysis.
On this particular point, the court has reviewed the transcripts of the depositions that were cited by the renewed motion. And the ruling will remain the same on this issue as before. These matters go to the weight of the evidence and not the admissibility. The jury, as the trier of fact, is going to decide what significance to give to the evidence. The defense also is free to cross-examine on all issues that pertain to Mrs. Adelson being free to trial. The matters that have been previously raised within the motion to suppress and rule on as to the phone calls and other evidence that also will be presented to the jury as well. They will make up their mind.
Thank you, sir.
Coming in.
Well, I believe that covers the defense motions. And Ms. Calvin, you stated that the state did not have an additional motion of remedies that not have been previously ruled on.
That's correct, Your Honor.
Judge, there's one additional one, also filed on July 21st, concerning the opinion testimony of Jason Newell and Patrick Sanford.
Yes, go ahead for that motion.
Sorry, Your Honor. I'll stand on the motion.
Ms. Calvin, with a response.
Judge, the defense elicited personal opinions out of these witnesses at deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Ms. Calvin, even though it might be required to deposition, ultimately, if there's a basis to exclude it pre-trial, that's why it's being raised.
Of course, there is no reason to elicit it at deposition, and that it could never be admissible at a trial. So we're just wasting paper and time. These motions. No objection.
The state is conceding the issue. The motion is granted as to any opinions that would be offered by an investigator or Special Agent Sanford. Again, there must be a proper foundation for them to offer an opinion on a subject that they don't have the ability to do so. It cannot be presented as a part of the case in chief. I don't really see a context in which this might come around either in rebuttal or as far as impeachment, but again, these rulings are being made as to the state's, the substantive evidence the state may present as a part of its case in chief. If it needs to be readdressed as a matter of either impeachment or rebuttal, I'll take it up at the appropriate time.
George is
Let's
exasperated.
go ahead and talk through some of the logistics for jury selection on 8/19. We are going to be in this courtroom once again. I believe the number of jurors that we have under summons right now, or prospective jurors under summons, I believe it's near 300. So what we're going to do on that Tuesday, essentially we will have the pre-screen of the jurors on the issue of pre-trial publicity, similar to what we did in the last trial. The court will be asking the same questions or substantially same questions. Both parties will have an opportunity to follow up on the court's questions on the issue of pre-trial publicity. If a prospective juror is deemed suitable to return for a group voir, from there they will be given the date and time for which group voir will begin. For the pre-screening that will take place on both Tuesday morning, Tuesday afternoon, potentially Wednesday morning and Wednesday afternoon, I would anticipate by that point we would have a suitable pool of jurors from which, going through the pre-screen process, anyone who has had an issue or either the court believes, the state believes, or the defense believes is not suitable to go to the group voir, from where each party will have an opportunity to make their objections known as to that prospective juror. and they'll be told to return, or they'll be excused at that point. Does anyone have a question about the pre-screening process?
No, sir.
There you are. Also, as well, so that we don't have any issues similar to what occurred in the previous trial, in which I believe there were allegations the jurors were speaking to each other. We are going to have additional bonus. The prospective jurors are going to be instructed not to speak to each other. It might make a long day for them, but they will be sitting in silence. We will provide reading material to them, and we'll have extra bailiffs on hand to ensure that no one is speaking to each other while they're waiting to be screened. Does anyone have anything they need to raise concerning those?
Is it your honor's intention to handle the pre-screening, I don't know what it's called, instructions that happen down in jury assembly?
Yes.
Okay.
I believe last time, I'm not sure if someone else qualified or not, but for each group that will be qualified, I will do it personally, so that way from beginning to end, they are seeing me, hearing me, and understanding you're not to discuss the case or anything else with each other.
Perfect, that's the state's request.
Judge, how many of the 300 are coming each day?
Broken up into groups of 50, so 50 in the morning, 50 in the afternoon. We may not even need to get to the end of this grouping altogether if we are able to go through the pre-screening process on the issue of pretrial publicity. Once we have, say, 100 to 110, that's more than enough to get 12 people.
How do you intend to handle the proceeding once we successfully select a jury?
Once we have selected a jury at that point, and also I believe too, we'll need at least 2 alternates unless the parties wish to have 3.
We defense would request for your honor.
But once we have our 12 jurors and 3 alternates, at that point, we will swear them. If we have enough time to actually move into opening on that same day at the selection, we'll do that, so that way we can start to begin into witness testimony seamlessly without issue. How many days is the state anticipating to go through its case in chief?
I think best case scenario is 5, worst 7. So 6. I could see how it could run into the first part of the 7th day, Judge, but I think 6 is a comfortable estimate.
Let me bring up my calendar. Assuming that we have a jury by Friday the 22nd, and we have that in place August 25th through September 7th as the state's case in chief. I think there is a holiday on September 1st, correct?
Yes.
Yes, sir.
Is anyone volunteering to work on Labor Day?
Jackie is.
I mean, one other hand, unrelated to that side of the table. It is a holiday for the workers of the world, but we cannot forget that we have a trail to finish. All right, 8:25 through 9:02, then estimating as the state's case in chief. How long is the defense estimating to present any case that it wishes to do so?
Can I weigh in on that before they speak, Judge? We have historically picked a jury in 3 days at the longest. Twice we did it in 2 days. So my suggestion would be to start on Friday. We could even do openings as early as Thursday, if your honor was willing to entertain that. I know that's not the defense's request, but that would be the state's request, just to move it on as quickly as possible.
Well, for the openings, only does the defense have a position concerning this.
We don't want to make openings unless we have a great deal of time after we pick the jury on a particular day. We would prefer to do the openings the next day.
So you're not asking to defer the opening to your case, you just don't want to open on the same day.
It's going to depend, Judge, on your ruling on the additional motion.
Oh, right? And that matter, again, depending on where we're at time-wise, I'll just instruct both parties to be prepared to potentially give their openings. I'm not going to place a time limit on the opening statements, but obviously, each party will be the captain of its own ship as to how you will captivate the jurors. Is either party expecting that opening to go beyond 30 minutes?
Depends on your ruling, Judge.
Ms. Capital.
Yes, I think it could be up to 45 minutes. It's not going to be different than it was previously, but I'm sorry, I don't know how long it was. I would say 30 to 45 is a comfortable range, Judge.
Right, as to the defense case, once we are finished with the state's case, how much time are you estimating?
It depends on your ruling, Judge, but anywhere between 4 and 6 days.
4 and 6 days. So that would place us then around the week of September 8th. Concerning any other matters that we can address as the logistics of the trial, I believe we will have rooms available for our family members, both for the victim's family and for the defendant. Do parties anticipate making use of these rooms?
Yes, Your Honor.
Yes, sir.
Right. Please contact court administration. From there, you'll receive information as to how to access the rooms and when they will be made available.
Judge, can I clarify your intentions about when to start testimony?
Go ahead.
You intend to start testimony on the 25th, is that right? With the possibility of openings having already been conducted?
Well, at the latest, if we go into Friday, we're getting to select a jury.
Okay. If we get a jury,
If we get a jury prior to that Friday on, say, the 21st, well, at that point, there's nothing preventing the testimony from getting started on the 22nd.
okay, so I'll be prepared to start testimony on the 22nd then. And my understanding was, and my subpoenas run through September 5th, but it sounds like we might be extending into the week of September 8th, is that right?
Well, I believe the defense is indicating they might need anywhere from 4 to 6 days.
That's what they said. All right, so we could potentially go through the week of the 8th.
If need be.
All right, I will attempt to get subpoenas out for rebuttal for that week, but I will advise the court that as of right now, those are not out.
We are losing a day because of September 1. But if need be, we can figure out logistically how to make this work for Saturday to continue working. I'm sure you all would like a break, but I'm here. Part of the matters of logistics that need to be raised concerning travel.
Yeah, Judge, we're going to have an issue regarding space. We're not all going to fit here. We also don't want our computer screens facing cameras and the audience being able to see what's on our computer screens. I have become very old, and the font size I use is very large, and probably someone in the back row can see what I have on my computer. So we're going to need to have, I understand we're blocked by this column,
Right.
but we're going to need to have some kind of setup where we can put our things and our defense not be disclosed ahead of time to the media and blogs and this and that. The second thing is these microphones used to have the ability that you could touch it and it would turn off. My client is hard of hearing, so she talks loud. So everything she says is going to be picked up. This one is now set up so you have to press it each time you want to mute it. And right, press and hold. You got to hold it down for it to continue to stay muted. And we're going to ask if the court admin could put it back to the function where we can push it off. I don't think there's going to be any opportunity in the trial for someone to not pick up on a recording of Mr. Zellman's voice. He's very loud. I tend to be loud too. So it's not going to be a record issue in our position, but it's certainly going to be a problem when we're trying to speak to our client about something because it's going to be heard.
Well, in front of the jury, definitely understand the concern that you're registering with this. Inquire to what can be done for the microphone and the table. If your client does need to write things down, so that way nothing is being given away, that might be the easiest way for that to be handled, but that requires the microphone. The seating set up in the gallery under the first two rows behind the defense, those are not going to be relevant to any members of the media. As far as the front side of your computer, if you need to rearrange how you're seated at the table, so if you need a seat on the far left, or my right, your left, so that way your computer can face the wall and no one can see it. I don't really know what I can accommodate you with as far as that font says beyond that.
Well, the problem is the end of the table it's not open. It's the leg of the table. So I don't know if we can add a little something, another table that is the same size.
Well, I've tried a 3 co-defendant first-degree murder trial in this room before, and what we had done was one table was between the column and the bailiff's box. There was a table here, and then this table here. I think that if we could put a table to our left, that might be one way of accommodating this table.
Right. We can make a request to the court and then we will figure out the best way to try to configure the tables. Ultimately, for that needs to come in with, I believe the state is going to try to, well, needs to bring in its equipment, audio equipment.
Yes, Your Honor.
Because of that equipment and how it need to be set up, the tables and how they're configured can't interfere with that, but we'll try to accommodate that as best as possible. This comment as to the audio visual needs of the state, other than what has been used before with the audio setup, is there anything that needs to be addressed?
No, sir, it'll be the same setup with the same company.
All right. Probably then they'll need to get started by the 15th in this room so they can set up all equipment, test the equipment, and if there's any problems, we'll be able to figure out what needs to take place before we actually get started on the 19th. All right. For the media presence that will be here as well, I believe it will be similar rules as it's been in the past. There will be one live video camera, there will be one still frame camera. Obviously, the bloggers and reporters, they are permitted to take notes as if they were print journalists. But the initial rows behind the state, as Captain, I assume the victim's family is wishing to appear.
Yes, Your Honor.
They will receive priority seating with regard to how they're positioned in the gallery. After that, it will be free to the public and the press to seat in all areas that are available. Does other party need to be heard concerning this?
Your Honor, we're also going to need space for our client's family and friends who are going to be coming to support her as well. And we would request that they have similar priority seating as the victim's family.
That's what the 2 rows will be behind the defense. That will be available to family and friends. Again, similar to the last trial, other than the video recording and still frame photography recording. Beyond that, no cell phones are to be out recording any other matters or trying to take photos of the witnesses or the jurors. I believe similar in the last trial when Special Agent Jimenez testified, his face was not shown, obviously because of the nature of his past work. The court will just make the same ruling concerning that as well. His face is not to be shown, but of course the substance of his testimony certainly may be reported on by anyone who believes it is newsworthy. During the selection of the jury, the faces of the respective jurors are not to be shown. Their names are not to be shared. But as far as any biographical type data, such as the composition of the jury, being, for example, 7 male, 5 female, what their professions are, those are certainly able to be reported on by the members of the media and disseminated. But ultimately, what I'm getting at is names and faces, so we don't have any disruption or disturbance during the trial. Do any of the parties have any questions concerning those?
No, Your Honor.
There you are. One last thing, typically, I don't think I've had a trial with you quite some time. Typically, my paralegal sits with us, so that's another reason why we need that additional table. She also may have some additional people assisting her. I'll make sure that they're identified as the bailiffs so that there are no issues there.
The members of the direct support staffs may sit on the benches that are behind the attorneys, or if we need to figure out a table configuration for them, if we have the space. But the direct support staff is permitted as to both sides. Does either party have anything further to raise concerning the logistics of the trial or any other issues before we finish?
No, Your Honor.
There you are.
One other matter comes to mind if the attorneys can briefly approach.
Oh, interesting. Here's a little sidebar within
Yeah.
this. Joe and I will go over what just transpired once this is fully over. You see Donna sitting there behind a
Right.
mound of paper. She's got her water. Just now, the defense was making the case for sort of re-altering their positioning because they don't want. You see the handcuffs there. They don't want Jackie Fulford specifically said they don't want people in the gallery to see. They have to use larger font because she is a bit older. Donna's hard of hearing, so she speaks louder. So all these little things that you wouldn't think of, they're bringing up. Also, very interestingly, Joe, Josh Zellman said after Georgia said that the Markels will need some priority seating, which he granted, Josh Zellman stood up and said that that Donna Adelson's family will be there too. So I'm
Family and
curious.
friends.
Family and friends. So,
Family and friends.
and by the way,
Well-
she does have, or did at one point have, quite a bit of friends.
Yeah.
You know,
And one consequence of that will be there will be fewer seats in the gallery for media and the public generally. And, remember, I think it was Dan Rashbaum who tried to exclude or wanted the smaller courtroom to keep the public out. This will have the same effect, not keeping the public out, but limiting the seats for the public.
Jackie Fulford called us media wonks, if I heard that correctly, which kind of irritated me. But the judge said, as typical in the last trial, one live camera, that will be the pool camera. And I believe it's going to be for this. I believe it's going to be Court TV. That's what I was told. And then one still photographer, typically from the Tallahassee Democrat, which is the local paper. But right now, Joe Patudo, if you had a guess, what are they talking about in a sidebar?
My guess would be it has something to do with why the trial started a little later. I mean, you heard the defense say they couldn't estimate right now how long their case will be because it depends on a ruling on a motion we didn't hear. I mean, she didn't say it that way, but there's a ruling sitting out there that the judge has to decide. And based on what he decides, the defense case will either be shorter or longer. But
I thought, did they throw any time? I thought they said roughly 4 to 6 days, right? Or no?
Yes, but they couldn't, they
There was
weren't
a
able to get
caveat.
any closer because it depends on the ruling on a matter that we're not sure, we don't know for sure what it was. Now,
Mhm.
they had that motion on the 2 informers for the states that wasn't heard.
Mhm.
There was an earlier request by the defense to use an informer or 2 on their side, but they never, there's no evidence that we've seen in the record that they deposed them or that anything happened there. So it's a little unclear what it is that they're arguing about, that's pretty clear that the state, I should say, my guess is that the defense wants to keep something out. And that's what the judge has to rule on. It may well be the 2 states informers, Bernhardt and Patricia Byrd. Yeah. And maybe that, and then the defense may want to add something on their side. We just don't know. But it's clear that there's something we don't know that's affecting the length of the defense case.
Yeah. Right now, if you want, let me know what exotic locale you're coming from. I'll have a list at the end of the show. Got the global audience in-house today. Let's see what this is about. It sounds like they're actually winding this down.
Yes.
Because there was talk that this could go in the afternoon. That is not going to happen. It's only 10:04.
We will be in recess for today.
There you go.
The jury selection will start August 19th at 8:30 in the morning after the initial group of jurors has been qualified. From there, we will move into the pre-screening process as previously discussed. Have a good day, everyone.
Thank you, Judge.
Okay. Well, they certainly covered a number of topics. And Joel, I don't know how you want to take these. I will tell you that I stopped listening when they were talking about computer screens and listening, because that's all logistics and they'll work it out. And so I figured they can do that and I don't have to pay attention to it, because whatever they're going to do, they're going to do. And the only thing that's clear is that there are going to be fewer seats in the gallery by the time they're done.
Yeah, well, let's just go back and kind of in order. So we knew at the beginning that they were going to be discussing some motions in limine. The first one was this dissolution of marriage. So let's start there, Joe Patuto. Let's talk about, and Josh Zellman specifically pointed to Chapter 7 of his motion. Georgia said that the divorce goes to motive, the intensity of the divorce, litigious nature. So just break that one down for us in terms of the dissolution.
Yeah, in the last trial, in Charlie's trial, you remember what Georgia used, particularly with Wendy, was that very, very, very deep divorce file. Josh Zellman said there are things in that file that are not relevant to any issue in Donna's prosecution, and Georgia essentially agreed that there are things in there that aren't relevant to this trial. She said she wanted the whole file in because it goes to the intensity of the divorce argument, and Donna's word choice, because she's quoted in there, or at least Wendy is quoted in there, how intense, how long it went, how protracted it went, and that all relates to Donna's motive in being complicit in the murder. And so she agreed with the judge that not everything in that file demonstrates that. Josh Zellman said there are things in the file that they haven't shown that Donna even knew about. So how can it go to her motive or intent if they can't show that she ever knew? And the judge agreed. But Georgia then said she didn't disagree with that, but she wanted to be able to go back through and pull out, or at least be available to say, here are all the things that are relevant. Judge agreed that if they can show the relevance, that would go in the case in chief. In other words, in Georgia's case to begin with. He also said that with regard to anything in that file, Georgia can use it on rebuttal or for impeachment. Impeachment would be defense witness gets on and says something. Georgia can say, well, here's something in the file. That challenge is what you're now saying on the stand. Rebuttal is bringing a new witness in after the defense finishes the case. In other words, whatever their testimony is, Georgia can't challenge on the basis of any particular witness who testified, but she's got a witness who can challenge it. She'll be entitled to do that on rebuttal. So we don't know whether there'll be when additional things may come in to impeach or to rebut, but the judge did limit to matters in that file that are relevant to Donna's trial. But he also agreed that Georgia is entitled to show the whole file as a demonstrative exhibit. In other words, be able to show it to the jury and say, this will show you how intense, how protracted, how angry the parties were with regard to each other. And then, of course, she's going to be able to tie it to the emails that Donna actually sent about what to do and how angry she was at Dan Markel. So I would say, on balance, I don't think the state will be affected much by the rulings. They're going to be able to get in what they most want to get in, which is look at this file. So tell me that this was amicable. Remember, Wendy testified, it was like any other divorce. It was pretty amicable. And then her divorce lawyer had testified and said, this is how divorces go. The file belies that. So that was what they did. That was the decision on that. That relates, by the way, to the argument they had about Stephen Webster on the stand and what he'll be able to testify to. He was Dan's last lawyer.
He's the describes himself as the post-divorce attorney.
That's right.
And Stephen's been on the show many times, a great guy, but he's also an attorney in Tallahassee. Right.
And the argument that the defense made was, because Steve, for anybody who saw that trial, he was an extremely effective witness, both to humanize and make Dan present in the courtroom as what a great father he was and a great human being that he was. But also he testified to matters with regard to the divorce and how the divorce proceeded, whether the claim that Wendy was hiding funds would be something significant, whether it would affect her bar license. I think he talked about that a little. And the defense challenged, saying he's not a divorce lawyer. On the stand, he said he had not done this sort of work, so he is not an expert. So with regard to what divorces are like, he can't testify to it. And Georgia agreed. So Webster will be able to testify to the things that were most evocative. Dan was a great person. He was a great father. He will be able to testify to how really angry the parties were, because that would be his observation. You don't have to be an expert as a divorce lawyer to be able to say that. He'll be able to testify to all those things, but he won't be able to say, this is how a divorce works, because he's not an expert with regard to divorce law. So that one relates to this, the issue about the file. They are trying hard to limit the amount of information that comes in that relates to the animosity that Donna would have had towards Dan because of the divorce, because of the post-divorce proceedings.
Yeah. I didn't even look at this comment. 5Car5, who's always here for this case. When Dan filed the motion for Donna to have supervised visits with the boys, that set her off. That court date was in August. So they had to do something before that date. Again, this is the point that Georgia was making, that the divorce is so important because it is, it goes to motive. By the way, a lot of new people here. Appreciate everyone being here. If you're not familiar with the show, we do a live panel show nightly, 7 p.m. Eastern time, and then on Fridays in the afternoon on the biggest cases, not just the Dan Markel case, but the biggest cases going on in the country. And you have amazing 3-panel guests like Professor Emerita Joe Patuto, who taught at the University of Nebraska School of Law and elsewhere. So if you appreciate the content, please hit like, please subscribe before you head out today. That helps us a lot. And if you want to read an amazing book, I wrote it. It's about my mom, a child Holocaust survivor, who's my co-host emerita on this show. Same title as the podcast, Surviving the Survivor, and it is available with her accent on Audible. Sarah Youssef.
Before we go on,
Yeah.
there was a couple of comments ago by someone, and I was going to point it out because it was something that Webster will be able to talk about. And if you can get back to it, because I'm not going to be able to quote it directly. Yeah,
COE. COE, can you help us with that? I'm not sure, but why don't you start to explain it in the COE? I'm sure we'll find it.
Yeah, it's simply that Webster can the question was, or the comment was about the hearing that was going to be held on Dan's motion or request that there be supervised visitation if Donna was going to be with the kids. That would be something that Webster can testify to. He doesn't have to be an expert on divorce law to be able to say he's familiar with the kinds of things in that proceeding that were going to come up. They bear on Donna's motive to the extent that the state will be able to show that Donna knew about it. And that was the argument that Josh Zellman was making. If she didn't know about it, it can't bear on motive. Wendy will be able to testify to that. There may be other evidence. Webster may know something about that, but those are the sorts of things that are not expert testimony from Webster as the last lawyer that Dan had. I just wanted to use that as an example.
Interesting. And then obviously we are looking at a picture of Donna. Joe Patuto, I don't want to put you on the spot, but what do you think? I mean, just physical appearance. Everyone's going to be looking at her. The jurors will be looking at her. She's a 75-year-old woman. I mean, she looks good to me. I know that's not a popular opinion. When she was at the time of her arrest, by the way, Joe, did they ever rule on the arrest video? Is that going to come in?
Well, the video can come. The argument was that you shouldn't be able to use anything coming from the arrest at the airport and anything else. And the judge said, it's admissible on consciousness of guilt. I said this once, I'm going to say it again. So yeah, they should be able to use it.
Yeah. But what do you think? I mean, I think she looks fairly strong. She's been in jail since November 13th of 2023. She was first in Miami-Dade County. There is video. And by the way, we're putting a lot more videos under our video tab, even though we do live shows. And, obviously not all related to Dan Markel. And I'll be putting together a video or two that will drop later today and or tomorrow. But those are under the video tab. But one of the things that we talked about at one point or showed was the transport video of Donna Sue Adelson from Miami-Dade up to Tallahassee when she was first transferred. And Joe, she didn't take it well. She had either a physical reaction or a mental reaction, like an anxiety attack. They had to administer some sort of, first aid, but she was shaking and really sort of flipping out on the drive up. But it's a stark comparison to today. I mean, look at her there. She looks pretty calm. She looks pretty collected. What did you make of her physically and sort of emotionally?
And she was smiling at times during this hearing. Well, you can't, what we don't know is what she will look like the day of trial. I mean, this is still not in front of a jury.
What's your guess? Is she going to look like a librarian?
Yeah, I do. But I think my guess is she will have makeup on. Her hair will be fixed better because she was trying on clothes that they brought into the jail for her. Mm-hmm. So I expect that she's going to look more put together by the time of the trial. We'll see. I mean, the other version would be that she comes in looking decrepit and old and, miserable. But I don't think that's the way Donna wants to appear in front of the jury. So I think she will be better coiffed than she is right now.
Yeah, by the way, last night we had two former female inmates talking and a former corrections officer, a male, talking about what life will be like for her if she is convicted and goes to state prison. Debbie Martin here for Joe, and feel free to drop in questions and I'll try to get some to Joe. We'll go a little bit longer and we'll still get through the rest of what was on the docket today. But Debbie Martin, Joe Patuto, Ken Webster mentioned the upcoming court date that was happening at the time and Dan's lawsuit over the assets. Some people feel that that's what put Donna Adelson over the edge.
He will be able to talk about the upcoming court date because that is relevant to how long, the length that those proceedings were taking. And the judge said length, intensity, all of that can come in. Dan's lawsuit over the assets, I think that's going to depend a little on whether Donna knew about it or not. And that's why Judge Everett said, you're going to have to lay a foundation for some of this, because you're going to have to, the issue as to the assets would certainly be relevant if Donna knew about them, because it would go to motive and intent again. She's helping out Wendy. But if there's no evidence that she knew about it, then the argument as to whether it's intent or motive is certainly at least much more tenuous, because she can't be motivated by something you can't show she ever knew about. So the question will be the extent to which Georgia will be able to demonstrate that she knew or likely knew. She might be able to do that by showing that Wendy told her everything, as things were going on, but that's likely going to be where it comes up. Yeah. If Donna gets on the stand, then the issue will be impeachment, and Georgia will have more leeway to try to explore those questions with Donna, such as, how often did Wendy talk to you about all this stuff? Weren't you really close? Did she tell you about this? How can it be that this is the one thing that she didn't tell you about? That would all go to impeachment. So if she gets on the stand, my very strong guess is the information will come in at least as impeachment.
Yeah, COE Joe had just addressed that super chat question. Thank you. I already forgot the name, but thank you. These super chats and others are fantastic, so appreciate it. Look at this, new to the channel. Welcome, Lynn, a retired defense attorney from South Africa. Wonder if you studied with Joe Patuto and then moved back to South Africa. Who knows?
Unfortunately, I never taught there. Taught in England, but not in South Africa.
Yeah, well, we might have to get you there. And that reminds me, we'll bring Dr. Melissa Hamilton back. She's a best guest. She was a corrections officer, a police officer, and is now a law professor in UK at Surrey, which is the law school. But so a lot of people were saying, who is Sarah Youssef? Who's Sarah Youssef? Well, Sarah Youssef is an old acquaintance, no longer though, of Wendy Adelson. And apparently she at one point reached out to Dan Markel's attorneys, who put her in touch with the government, with
No. She reached out to the family. The family got in touch with their lawyers. The lawyers got in touch with the state.
Yeah. And
she
so,
been able to.
But Georgia made it clear that she is not being called as a witness unless it's some sort of rebuttal witness. What do you make of that? Does that just mean that whatever Sarah Youssef had to say wasn't that important?
Well, it's more difficult to get it in against Donna than were Wendy being tried.
Correct.
And so that would be part of the reason. If Donna testifies and says, we got along, I made him banana bread, Wendy has said that, then Sarah Youssef can say, that's not what she was saying when I met her, right after the killing happened. And she will then be able to talk about some of the things that she told the state. But what you get from Georgia is two things. One, it's not as relevant to Donna, and two, you're right, the state doesn't think they need, because of all the other evidence they have, they don't think they need to go there to get this bit more. But they're reserving, if Donna gets on the stand and says everything was copacetic, to then call Sarah to say, no, it wasn't.
Joe, by the way, before we get to Abby Crossing, friend of mine, friend of the show, friend of the COE, and helps us out behind the scenes. But before we get there, I mean, what do you make of the fact at one point, just in terms of the calendar, which we will get to more fully in a second, but at one point, Georgia said, well, let me clear my calendar out through the week of September 8th. So the judge, he likes to have the holidays off, and he already made it clear that Labor Day, which I believe is September 1st, they're not going to be in session. So Do you really think this is going to start with jury selection on the 19th and go into the week of the 8th? I have a very hard time seeing that or buying that.
It depends on how much of a case, I don't think so either, but it depends on how much of a case the defense makes. It depends on how many arguments we're going to hear, probably not hear. A lot of it might be sidebar on what the witnesses are going to be able to testify to. It will depend on whether Georgia puts on a rebuttal case. I mean, there are all kinds of things that may impact how long this goes. I thought Georgia's estimate of we got the jury selected in maybe 2.5 days the last time, I don't see it going any longer, was a little optimistic, because what the judge is going to do is they're going to do the traditional start with the big jury pool, but then they're going to go into talking to them all about the pretrial publicity. And that's going to be extra time before you can seat a jury. He was estimated, what did he say? Morning, afternoon? I thought that's what I heard him say.
Yeah, he said that he thought they would get, so jury selection is going to start on Tuesday the 19th, and he said that they should have a pool to choose from, he thought, by the afternoon of the next day. On when he said a Wednesday afternoon, which would be the 20th.
Yeah, so he said morning, afternoon on Tuesday, morning, afternoon on Wednesday. Then they're going to get to the other part of jury voir dire. So I don't see how it's, I mean, she's closer to it than I am, but I don't see how they're going to be able to do that. If it takes that long to do the pretrial publicity vetting, and then they're still going to do what they would do in a normal jury selection voir dire, seems to me it's going to have to take a little longer than that.
And then Jackie also said, hey, we don't want to seat a jury and then do openings right after that. We want a day, the next day.
She said a day, unless the jury selection ends early in the day and they can do the openings later in the day. She left that open. Otherwise, it would have to be the next day.
And by the way, and I'm going to get to Abby's question, but Jimmy McNutty, now I lost Abby's question, but I'll go back and get it. So a pool of 110 to select the 15. I'm surprised. It sounds like there's only going to be 3 alternate jurors.
I was surprised too. Yeah.
Yeah. And last time there was 6. And one of the alternate jurors last time, we didn't know at the time whether that person was an alternate or not, but one person was making very obvious sort of faces, and people didn't know exact. They thought that this particular juror was leaning toward the defense. But in any event, I'm surprised, because there was discussion about that juror during the trial, and with that in the rear view mirror, Georgia, I just called you Georgia. Joe, I'm surprised that there's not going to be at least 6 alternates.
I was surprised too. I would have gone for larger alternates just in case something came up. I mean, particularly given the murder was 11 years ago now. They've done several trials. They had one mistrial. I would have been overly cautious about getting enough jurors so that won't be an issue. But, Judge Everett has a whole lot more experience than I do, clearly. And he's got a whole lot more experience clearly than I do, because I have none with regard to Tallahassee jurors and how many alternates you need. So I guess we should trust him on this. The other thing you heard him say, and this relates to Charlie's appeal, since we're on the jury, the prospective jurors are going to be instructed that they are not to talk to each other at all. They can bring a book, but they cannot talk to each other before they're seated in a panel. That's the issue that Charlie is raising on his appeal. He's got information from at least 2 prospective jurors that there was some discussion, even though the judge said, don't talk about this case, don't speculate while you're sitting in the jury pool room, that they talked about this was a murder case. Somebody said, gee, I think it relates to that law professor. They weren't supposed to talk about it. Charlie says, gee, my jury was tainted by that. And Judge Everett is taking that issue out of this case. They are not allowed to talk to each other. They may be there all day, and he's putting more bailiffs in that room to make sure that nobody talks to each other.
So finally, Abby Crossing has been waiting patiently. Professor Petuto, think they will bring in the Wendy police interview for the first time, because on there you can hear Donna's reaction when she makes a call to her mother Donna during that police interview. You can hear Donna's reaction or lack thereof on the other line. Is there a chance? That's an interesting question that they bring that in, Joe.
Yeah, my guess is no, but it's only a guess. Again, because I think Georgia thinks the case that they have is really strong, and whether she thinks, although I think Abby Crossing is right, it might help a little, but it's, it's taking you off on not a tangent, but it's taking you away from the straight, let's go from here to a conviction straight line. So my guess is no, but Abby Crossing, it's purely a guess.
Yeah. Next motion that was discussed as we go and tick these off of our little docket chart here. The motion in limine regarding being able to refer to Luis Rivera as a member of the Latin Kings gang. If I understand this correctly, Joe, basically Georgia doesn't want him characterized as a gang member. Is that right? Because
she doesn't want him characterized as a gang member of the particular Latin Kings gang. What was the compromise last time was that they could say he was a gang member. They couldn't say Latin Kings. She also doesn't want him identified as a leader of the Latin Kings gang. So that issue, part of the question was, what did the undercover agent actually testify to the last time, and will he testify to it again? He never said he was a member of the Latin Kings to Donna during that bump.
Right.
Pretty clear he was, that there was a gang out there, but he never said Latin Kings. So part of what happens will depend on how that evidence comes out at trial. Let me see if I got anything else in that. Part of the issue, and you heard Judge Everett raise it, I was thinking the same thing. He asked, is it likely that Donna knew there was a significance between being a gang member and being a member of the Latin Kings? Did she know that there was this gang that presumably was worse than other gangs? That was my question. The judge said if to show that she knew, because Josh Zellman said, we want to show how upset she was, how afraid she was, how frantic she was. Now, of course, that's belied by her behavior in the bump. She didn't look frantic or upset or anything else then, but he wants to be able to use that. The judge said, you're going to have to show some foundation that she knew. And he said, well, when she testifies, or if Charlie testifies, that information that she knew will then come out. And if so, if she knew, then it may well be relevant to her state of mind at the time, and then the ability to say Latin Kings, or maybe even leader. I'm still doubtful about leader of the Latin Kings, because there would be no way she would know that. The only way she would know that he would theoretically, that he was a leader of the Latin Kings gang, is if Katie Magbanowa knew that Luis Rivera was part of the murder duo, told Charlie that he was part of it, and then Charlie told Donna. I don't see any other way that Donna could have known. I don't know whether they're going to be able to show all that, but that may be why Josh Zellman mentioned that Charlie, if he testifies, might be able to connect it and let it all come in. So right now, what the judge decided was what he decided last time. They can reference the fact that that Rivera is a gang member, and they can use that to show that Donna was really afraid. But to get in more, the leadership role, and he was a Latin Kings gang member, is going to depend on how the evidence comes in at trial.
Here's another question from Willow Armadillo, and it rhymes, and it's an armadillo, but that is that an arm? No, that's a dog. That was weird. That was one of those, like, I just had an optical illusion. I couldn't tell what that was, and then I saw it all of a sudden, but it's a dog. Wasn't there a recent investigation of new phone data, and is it admissible? So what about where are we with all the the new wiretaps. I believe Georgia at one point said she was planning to try to admit just 2 of whatever they got. But some of that stuff is still, I believe, outstanding. How would you address this question from
Yeah,
Willow
that's what I think it
Armadillo?
was Sarah. Oh God, now I've forgotten her last name. Sarah, the other prosecutor,
Oh, Sarah Dugan.
Sarah
Yeah,
Dugan,
I was confused.
said
Yeah.
2 or 3 phone calls is all they would be introducing. The question is going to be if it's relevant to anything in Donna's defense. If it's phone calls, well, the phone calls that they tapped were phone calls between Donna and, we believe, Harvey, because the information was, or the claim was, that she was able to use one of the tablets or phones that I think it would have been Jackie Fulford had brought into the jail and had talked to Harvey. And they were able to get a warrant, a wiretap order to tap those phone calls. So those are, I think, the phone calls they're talking about, because the information with regard to the 2 informers, I don't recall any information that came through a wiretap. That information came from the 2 informers themselves and the interviews that Georgia had with Sarah Bernhardt, the first informer. So I don't think there are any phone calls there. The phone calls would be Harvey and Donna. Presumably it's Donna and Harvey from what we know. And they presume if they're relevant, they will come in. We don't know if they're relevant or not.
Yeah. People are commenting on my quickly declining. I had 20/20 vision. I'm in my mid 50s. I had it till my at least early 50s, and then all of a sudden it has been downhill, and I don't really know. I guess I need an eye exam, Joe Patuto, because it keeps shifting on me. But so Zellman got up there, Josh Zellman, to me, the defense attorney, and he basically implied that saying Donna's going to be testifying. What do you make of that? I mean,
He
there
didn't
was,
imply, he said it.
Yeah, I mean,
twice, at least twice.
And we sort of expect it, because she's got to, she has to explain away this story. And look, I just want to caution everybody, and this happened with Charlie, if you remember. People were worried, hey, how's he going to be testifying? And I remember everyone was sort of upset, and the tide turns quickly. And I know that better than anybody else, because I can get beat up real fast on a dumb mistake or whatever. But people all of a sudden were upset with Georgia that she wasn't tough enough on Charlie, that Charlie's testimony was so smooth. In this instance, Donna is going to get up there, and she is going to be very demure. She's going to look grandmotherly. Her glasses might be sliding down the bridge of her nose. She is very smart. She's street smart. She's shrewd. She's going to talk to the jurors. Are you concerned about her testimony before these jurors, Joe?
I guess I would say no. I actually don't think she's street smart. I think she may be book smart, but if she were street smart, for me, she wouldn't be blabbing all over the place about things that she shouldn't be talking about to anyone. She'd keep it to herself. And she may be able to do fairly well on direct examination. They're going to prepare for that. So she may be able to do fairly well with the question and answer from her defense lawyer. But I am not at all confident that she'll be able to hold up well on cross-examination. It's pretty hard to keep, I'm assuming she's lying about a lot of it. It's pretty hard to keep lies straight. If you're telling the truth, it's pretty easy to do it. But if you have to keep straight a number of lies, it's pretty easy to get tripped up. So it will be, I think that the proof in the pudding with Donna will be cross-examination, and I do not think she will do very well on cross-examination.
And Joe, that is, you stole my question from me. So explain the sort of the proverbial opening of the door in law. So Donna's going to get up there, presumably, and she's going to testify. And Georgia Kappelman's ears are going to perk up, and she's going to have a pen in her hand, and she's going to be jotting down notes. And Georgia is not going to be timid ever, and she will likely try to eviscerate her on cross. So what How does that process sort of play out in real time as Donna is testifying?
Yeah, well, let me start with the difference between direct and cross. Direct examination is your witness. You're not allowed to ask leading questions of your witness. You're not allowed to say, and when you had the knife in your hand, didn't you? That's not permissible on direct. On direct, you ask the questions. The information should come from the witness. The scope of direct examination, and this depends state to state, but the general theory is, if I ask you, let me give you an example. If I ask you about your relationship with your parents in Miami from 2005 to 2010, and now you're done on direct examination, prosecutor gets up and wants to cross-examine. The prosecutor can clearly ask you anything she wants with regard to your relationship with your parents between 2005 and 2010 in Miami. The question is, how much more can the prosecutor do on cross-examination? Can she ask about your relationship with your parents generally? Can she ask about, well, what about 2011? What about 2012? Somewhere in there, and it's a mushy line, and different states allow a wider and wider berth for this. But somewhere in there, you get beyond what happened on direct examination. Now, you may still be able to ask that witness those questions, but you have to make that witness your witness. So if Georgia wanted to go farther, she might be able to call, she's not going to be able to call Donna, but she might be able to call a rebuttal witness to do it. But you're just not going to be able to go full throttle as far as you want, because now you've got Donna on the stand and you really want to know, gee, what happened the day before the murder? And what's this business about the TV mean? There's a point at which you're going to be controlled by what happened on direct. Having said that, my guess is everything Georgia's going to want to pursue, Zellman or Fulford, whoever is going to do the direct, will have to ask on direct, because they're going to have to go through and try to anticipate the weak places in their state and get in their case and get Donna to give the story. So I don't think you got to stay within the scope is going to be an issue here, because they're going to have to ask a wide range of questions on direct.
And Josh Zellman's been doing this a long time, and whoever's doing the direct, and it might be Jackie Fulford, who's also been doing it a very long time. They're going to be careful with their line of questioning, and they're going to obviously coach her, right? They're going to say, Donna, I'm going to ask you this question, and you just give me this answer. Do not extend it beyond the scope of my question, right? Like
that's right. But there's a point at which they're not going to be able to control it. There may be some arguments. We may hear an objection from the defense saying, that's beyond the scope of direct, and the judge will have to decide, when you're out in this area here, is it beyond the scope, or is it within the reasonable range that is suggested by the direct examination?
So we've got Donna testifying. One of the other things that came up, Joe, the interpretation of emails, phone calls, and recorded messages. What was the bottom line with that?
Well, if you're an expert, you can give an opinion about things. Going back to Webster in the issue about how unfriendly the divorce and post-divorce proceedings were. Webster is not an expert. He can't talk about how divorce proceedings typically go, but a divorce lawyer may well be in a position to qualify as an expert with regard to that. So the issue that's coming up with Corbett and Newman and Sanford and Isom is you've got text messages, you've got emails. I can read them, Joel, you can read them, anybody in this chat can read them, and we can for ourselves try to figure out what the message meant, what the response meant. For example, the issue of the night of the murder, Harvey and Donna driving towards or going to Charlie's house. There's an argument when Charlie responds in 10 minutes or however he said it. Does that mean he's going home, or is he just telling them, well, I'm 10 minutes from my house? You don't need an expert to do that, because what the police officer might say is the meaning. I'm a juror. I might think it means something else. So you cannot, two things that they can't do. They cannot interpret for the jury those things that people with their own common sense can make their own judgment about. They're also not entitled to talk about things that you have to be an expert to be able to testify about. That was my first example of the divorce lawyers. So what the defense's claim wanted to get a ruling from the judge in advance is these witnesses cannot testify to anything that's in the general realm of what everybody would know, and they're not going to be able to testify to other kinds of things because they're not experts. And both of those things are true, but the problem is we don't know what it is they're going to want to testify to until they're up there. And that's what Georgia kept saying. You got to wait until they're on the stand to try to decide what's going on. And the judge said, well, if this comes up, Georgia agreed you couldn't get an official opinion testimony unless they can qualify as an expert in that area. And the judge said, we'll wait. And if you want to get something in, let me know. And you'll have to establish a foundation for it. So that's where that was left. And she didn't have any problem with it, because they'll have these sorts of things they're going to argue about when these witnesses are on the stand.
I hate to be petty, and I didn't realize it was I honestly did not realize it was going to be a pun, but Jackie Fulford really does look like she could be Tom Petty or Tom Petty's sister. And she looks awfully similar as well to Donna. So that was, everyone kept commenting on the similarity between Jackie Fulford and Donna. But if you've never seen Tom Petty and you've never seen Jackie Fulford, I wonder if they are lost brothers and sister. May Tom Petty rest in peace. Joe Patuto, you've got the Vietnam motion as consciousness of guilt. So for those who are somewhat new to this, in the week after Charlie Adelson was convicted, November 6, 2023, she spoke to Charlie for like 5 hours a day for the full week. But during that time, she was speaking to a company called Indochina Sun Travel. She was WhatsApping with them and trying to expedite visas to get over to Vietnam on a one-way ticket via Dubai. Where do we stand with this, and what can come in?
Yeah, the judge had already ruled on that, and the defense wanted to re-raise it, and they claimed they had new evidence, and they didn't have new evidence. What they had was one of the investigators saying, well, there was no arrest warrant, so she was free to leave. And her first lawyer, what was her name? I don't have her name written here, but the first lawyer that she had, who also told her that she was free to leave. And they said, now this is new evidence. Not new evidence. There wasn't an issue as to whether she was free to leave at that point because there was no arrest warrant. Nobody's contending that she wasn't free to leave. So it wasn't new evidence at all. And the judge said, I ruled on this already. The question is not whether it should come in. You make your argument that it doesn't really show consciousness of guilt. It shows, she testified at that hearing. She just needed to get away, and they picked Vietnam because they wanted somewhere where they could get back quickly if they needed to on their own terms, rather than be arrested and be brought back. So there was no question that I think might have been the easiest motion today of all. It was easy the first time they made it, and it was just as easy the second time.
Yeah. By the way, I think it was Abby, and maybe not, so forgive me, but someone asked, well, how about Harvey? He's on both witness lists. So will he be able to sit in the gallery and watch this trial as an observer, or only after giving testimony?
Typically, either side can make a motion with the judge to exclude until after the testimony. Whether that happens, we'll have to see.
And
I wouldn't be surprised if he's not called by either side, by the end of the day.
Yeah, the other stuff we went through, jury selection issues, which the judge said that they were going to try to have a pool done by the following day, starting on Tuesday, the 19th. So by the end of the day on the 20th, at least a pool to pick from. Again, only 3 alternates, 12 regular jurors, 3 alternates. Those 3 alternates make me a little bit nervous. Someone here saying you can't coach a narcissist because they know best, and that might be the case with Donna. We don't know. And then the last item was the calendar. Georgia saying 5 to 7 days for the state's case in chief. The defense saying we just don't know. It depends on some outstanding motions, but roughly 4 to 6 days. But for whatever reason, they were talking about and they always overshoot. I mean, as a safety measure. But they were talking about Judge Stephen Everett about the week going even into the week of September.
Yeah, and that
8th.
was because if you take 7 and 6, you're at 13, and that's 2.5 weeks before we even do anything. That's not counting jury selection, and that's not counting whether anybody calls a rebuttal witness. That's how they were getting so far down the calendar with regard to it. And I might say one thing I should have said before with regard to Donna testifying. I think she will. I think you're right, Joe. She's got to. But the fact that he says at this hearing she's going to testify doesn't mean that he has to call her or that Fulford has to call her.
Right.
I mean, they can say whatever they want now. And tactically, sometimes a lawyer might say, hey, I'm going to call, X to testify, because then the state has to worry about preparing or vice versa. The state says we're going to call somebody. The defense has to worry about all the extra prep. But there's nothing that they say in any of these motion hearings that requires them to call any of the witnesses that they're saying they're going to call.
Jimmy McNutt, saying I'm worried I am missing CrimeCon. I am choosing to be at the Donna Adelson trial, which is going to be right smack in the middle of CrimeCon. But this is the actual crime, where CrimeCon is a conference or convention about crime. So I'm going to be at the actual thing. Eve here. Great discussion. Love Joe. She's so smart. There's no second name there that ends in EL, just Joe. It wasn't Love Joe and Joel. They are so smart. Just Joe, J-O.
That went without saying. She didn't have to post that.
Yeah. So that's pretty much a wrap on today's hearing. It went much shorter than I thought anybody. And people thought it could go into the afternoon. Not the case. It started about 9:12, went to about 10:03 roughly. It's now 10:50 local time. But amazing to get Joe's insight. Joe, just want to give you a chance for a final thought. This is it. This was the final hearing, as far as we know, prior to the beginning of jury selection, which is 1 week from Tuesday, on August 19th. So your final thoughts as we say goodbye in just a moment or two.
Yeah, one of my final thoughts, I think, is probably pretty petty. I was happy to see Georgia display exasperation at the repeated motions and, what did she say, all the paper and stuff that didn't need to be filed because nobody's going to do it anyway, and I don't understand what they're doing. I like to hear that because it seems to me they've got to be just driven crazy by all this. I also thought it was pretty interesting, although Judge Everett at the end made a couple of jokes and smiled. He certainly didn't come out to the bench smiling at all. And so I would love to know what it was that happened before he took the bench and what it is that he still has to rule on to decide with regard to evidence coming in that the defense is waiting on. My guess is he will make that ruling. We may not know, because if this was under seal to begin with or in camera to begin with, we may not see that either. But my guess is that whatever it is he has to decide, he will decide before voir dire, because both sides need to know if they want to refer to it in an opening statement. And particularly if it's something the defense wants. He doesn't want an appealable issue because he didn't tell them until after opening statement. And they then can argue that their case was prejudiced because you need to tell the jury at the outset. It isn't enough that you can tell them later. You need to set it up so they have your view of the case in mind. So those are really my thoughts. I'm just glad that it looks like this is going.
What about Georgia? She's been doing this for such a long time. This case has been going on for such a long time. She knows the case inside and out. And people are like, she is cool as a cucumber. But you think underneath that, as we head into trial, nerves start to brew. You think she's tense on the first day, or you think she's just such a pro that she's just ready to go?
I have never known a lawyer going into a trial who doesn't have nerves, particularly on the first day. No matter how experienced, no matter how competent, no matter how well he or she knows the case. I just don't know anyone. And I knew a lot of prosecutors, fair amount of defense lawyers. I just don't know any one of them who would have said, they had no nerves, on the first day, at least on the first day. Just don't know it. I know several who say they couldn't eat or sleep coming up to a trial, no matter how professional and experienced they were. It's, you get up for a trial. It's a lot like doing a performance. You get really up for it, and it takes a lot of emotional energy. So I think, I don't know that I would say nerves in the sense she's worried about it, but just nervous energy. Yes, I do think she has it.
Yeah, and a final question, because this came up much earlier in the chat, and I thought it was interesting. Do you think that once Charlie was convicted, a few people suggested that they should have indicted Harvey, Wendy, and Donna as co-conspirators in this murder for hire plot and tried the three of them together? Just curious about your thoughts of that, because this has gone on so long.
Yeah, they know the case better than certainly I do. And they seem to think, and they thought from the beginning, that they needed Wendy's evidence to really nail the case. I have I can see what evidence we have that we see at a trial, but I'm not making that tactical decision for them. They're the ones who have to carry the burden of proof. If they feel that they need Wendy's evidence to really make the case, then they could not have joined her in any of the trials because she wouldn't have testified. So that's my best explanation for, if they're going to try Wendy, why they haven't done it sooner. Harvey is the hardest to get because he doesn't have a concrete track record. He's lurking around, but there are no emails from him. The one conversation that might have given us really strong evidence against Harvey was the one that they couldn't get a tape on at all. The one that where they by the pool, there was somewhere out of reach of where the undercovers could do a good recording. He's not on the phone. He's not the one running around making all the frenzied arrangements for Vietnam. He's going, but he's not the one who's arranging for somebody else to pay for the ticket. He's not the one calling Scott Radius and saying, is there somewhere we can stay? He's not the one emailing with whoever the agent was about, can we get an extended visa when we're there? He's not the one saying we need to get the wills in order and all the paperwork done. He's there all the time, but he's never the one who's got a footprint in any of it. So he's the hardest one to get. And they may have felt they didn't want to muddy the waters with Donna's case by bringing in Harvey, where it would be a weak case and maybe the jury would be persuaded that, the evidence wasn't strong enough against either. So.
And listen, I see a lot of familiar names in the chat, and a lot that I've never seen before, including John Baumer here, coming to us from Warsaw, Poland, of all places. But love having the support, love seeing everybody, all the familiar names. I can't go through them all because there's way too many. Our mods are amazing. They really put together a great chat day in, day out. For those who are new, again, we do a live panel program with 3 guests, the best guests in true crime, every night of the week, except Friday. We do an afternoon show on the biggest trials. This right now will be the biggest trial going on in the country, in my opinion. And then we also do a lot of other stuff. For example, I just did a in-depth look at the prison where the man who was convicted of murdering the 4 University of Idaho students is now going to spend the remainder of his life. You hit the video tab, you can find it there. But We have the best guests and a better community. Joe Patudo, among the best of the best of the best, she is the professor emerita, University of Nebraska Law School. She's taught all over the country and the world, and is an Italiophile. Loves spending time in Italy. Who doesn't?
Who wouldn't?
Yeah, who would not? So on that note, love you, America. Love you, Joe Patudo. Here are the countries that were in the chat today. Just some of them: India, Scotland, South Africa, Germany, New Jersey. I know that's not a country. Toronto and Montreal, Canada. Manitoba, Canada. Switzerland, Stockholm, Sweden, the Netherlands, Australia, the Kingdom of Lesotho. I don't know if that they were in the chat, but I have to include them. Serbia, my beautiful mother's home country, formerly the Yugoslavia. Croatia, the other half of the former Yugoslavia. Mexico, Alaska, Hawaii, Jerusalem, Israel, northern Wisconsin, Queens, New York, from Kings come Queens. That would be Run DMC. Alabama, Moab, Utah, Nashville, Tennessee. I don't know how to pronounce this, but Jinan, China, Jinan, China. Sunny, England, Lisbon, Portugal, Bali, Indonesia, Warsaw, Poland, and of course, last but not least, you've got Tallahassee, Florida was in the house. Dan Markel is born in Montreal, raised in Toronto, Harvard undergrad, Harvard Law School, and it's all about justice for Dan Markel, not her. There you go, Dan Markel. And big shout out to all the people who are watching us in Tallahassee. Love you, America. Next week's the last week of shows before the trial begins. We'll be here. Hope you're here. Big thanks again to Joe Patudo. We'll see you on the flip side. I'll be putting together a couple of videos today that will be under the video tab over the weekend. See you soon, and have a safe weekend, everybody.
So long.